So it's 3 p.m. and it is September 22nd for anyone listening to this later on. We are trying to keep everyone informed real time. And the reality of the current situation is that it is evolving and we are learning a lot every day as we go. Um, and I want to just thank everyone for being here. We have a lot of folks that have signed up and are seeking quality information. So first of all, thank you all for trusting us as a partner that we've strived very hard to provide quality information over the years. And I'll start with just some introductions here. And I'll start with myself. My name is Danielle Goldman. I am CEO of the Build Fellowship and Executive Director of Open Avenues Foundation. If anyone is unaware, Jeff and I actually co-founded these entities together to provide a cap-exempt H-1B solution for folks who lost the H-1B lottery and needed this cap-exempt H-1B as a plan B. We've been building this and running this successfully for 8 years. So H-1Bs are what we do day in and day out, and you're in the right place to learn a little bit more here. It's a really crazy time, but we want to be able to be supportive with good information as it's coming. So I'm going to let Jeff and Malvena introduce themselves, and we'll dive in.
Well, thanks, Danielle. Good afternoon. I'm Jeff Goldman. I've been practicing immigration law for 31 years. And most of my practice is representing technology, pharmaceuticals, all sorts of businesses for legal immigration, coming and going of foreign national employees. And my law firm is based in Boston.
Hi, everyone. My name is Malvena Driscoll. I've been practicing immigration law as an attorney for 23 years and involved in working in immigration law for close to 30. And I've been with Jeff and his firm since 2011, practicing exclusively in employment-based immigration law.
Awesome. Thank you both so much. So everyone hopefully knows we are in good hands here with the Goldman and Partners immigration team. I also just want to start by taking a moment to take a breath together as a group of 368 people that are on this call right now. This is a pretty wild time, but I want to acknowledge that the Trump administration, by putting out a proclamation at a late day on Friday, right before the weekend, had an intention to create chaos and uncertainty and stress for everyone in the community, including attorneys and companies and foreign nationals. And that intention of chaos obviously resulted in anxiety, but we don't, things typically with the Trump administration get walked back, get clarified, and hopefully get fought in a court of law in some of these cases as we go. So I think it's important that we recognize how many people are out there that are going to fight on behalf of this community and foreign nationals that are in this position right now. Obviously, we're not naive. There's going to be change that will happen, but we obviously need to wait and understand what is ultimately going to be the end scenario, because today information is fairly incomplete. That being said, we're here to give you the most complete version of what we know today. And so I'm going to start by just asking Jeff to give the first overview of what we know right now about the proclamation, timing of when it was when it was initiated, and who it is immediately impacting.
Sure. I want to start by just focusing on the actual proclamation made by the president last Friday afternoon. The entry, the beginning of the proclamation and the opening paragraphs tell a lot about why this is happening, at least according to President Trump. He feels that H-1B workers are dominating the IT industry in the United States and taking jobs away from U.S. workers. And he blames the H-1B laws for being too open, too easily manipulated. That's the word he used. And so he aims to solve a problem, which he thinks is the loss of jobs to U.S. workers. He wants to solve the problem by implementing a new $100,000 fee in certain situations. Among the problems, uh, President Trump says, the number one issue is the IT outsourcing companies who are bringing over thousands and thousands of H-1B workers and placing them at companies all across the United States. And he claims that oftentimes these workers are earning less than the fair wage earned by U.S. workers, and they're driving down wages. I don't actually understand how that could happen if the government would just enforce their own laws, because the law requires all H-1B workers to be paid at least the fair wage that are paid to U.S. workers. And it just seems to me that if you want to solve the problem of IT outsourcing companies, enforce the law. You know where their employees are, you know what they're earning, and if they're earning too low, stop it. Ban these companies from using the H-1B visa as a way to bring in foreign workers. If you think other U.S. companies are abusing the law by laying off U.S. workers and replacing them with H-1B workers, then enforce the law. The law tells the government, stop this. You have the right to stop this from happening. You have the right. You know when this is happening. You can see it. A simple audit would detect it. And what the government really should have done is enforce the law. Instead, President Trump has come out with this idea of imposing a $100,000 fee on future H-1B workers who are coming into the United States. And here are the key points from his proclamation and from the corrections and explanations that have come out from both the White House and the federal government over the weekend. Of course, I have to say, had they just simply brought an immigration lawyer who practices H-1B visa for a living, they could have solved almost all of these problems because we know what's really going on. We know where the confusion is and we know what the problems are, but they clearly didn't. And that's why they had to come out with at least two corrections and explanations. But after all is said, here's what the rule is. For any employer who has already filed an H-1B petition prior to September 21st, yesterday, if it was received by USCIS, actually by Saturday, the 20th, if it was received by USCIS on Saturday, the 20th, or before, the beneficiary of that H-1B petition is not subject to this new $100,000 fee. It's only for those H-1B petitions that are filed after Saturday, and that started with today. So those petitions filed today and moving forward are subject to a $100,000 fee if the foreign national is outside the United States and entering the United States in H-1B status. If the foreign national is already outside the United States, the fee is going to be imposed immediately. When the employer files an H-1B petition, they have to pay the $100,000 fee at the time of filing. So while there are some H-1Bs that can be filed today, these are not the H-1Bs that are subject to the annual cap of 85,000. Those are all gone, and it's not possible today to file an H-1B petition that is subject to that annual cap. But it is possible to file a new petition today in a cap-exempt H-1B situation. Those are for certain employers who do not need to enter the lottery. Those petitions that are filed today or later must attach the $100,000 fee if the foreign national is outside the United States. If the foreign national is inside the United States and a new petition is filed today or anytime after today, the $100,000 fee does not need to be paid if the employer is filing an extension or an amendment of a petition that's already been approved, or if the employer is filing for a change of employer for someone who's already won the H-1B lottery and is now changing to another employer. Because that person is inside the United States and the new petition is asking for the person to remain in the United States and legally be able to continue working in H-1B status. It has nothing to do with an entry into the United States. So no fee is due at this time. However, if a new petition is filed starting today or after today, and the foreign national departs the United States after the petition is approved, and now is planning on re-entering the United States in H-1B status, the $100,000 fee is due. It's not really clear how one pays that $100,000 fee. The government hasn't said, do they pay it at a U.S. consulate when they need to get a H-1B visa? Do they pay it at the border as they're entering on H-1B? Or will they pay it ahead of time to some address in the United States and get a receipt, which will then permit them to either get the visa or enter the United States in H-1B status? We don't really know. Ironically, I'm not sure we need to know because I don't think anybody is ever going to pay this $100,000 fee. It's prohibitive, and from the biggest companies to the smallest to the most well-funded venture-backed startups, I don't think anybody is really, very few people are going to end up paying this $100,000 fee.
Mm-hmm. Can we walk through a few, Malvena, anything to add to Jeff's overview before we walk into some scenarios?
Well, I think it's important to read not only the proclamation, but especially the subsequent memos and guidance that came out over the weekend by USCIS, U.S. Customs and Border Protection, and the White House. They came in a flurry over the weekend because it was very clear that the proclamation itself was not well written. It was not very specific, and it painted a broad brush when it came out that if you were not here in the United States on U.S. soil by midnight on Sunday with your H-1B status or visa, that's it. You wouldn't be getting back in without paying the $100,000. They saw that the panic had set off and that it really was not written clearly. The guidance that came out from, again, from USCIS, which issued a memo on the 20th on Saturday, Customs and Border Protection on the 20th on Saturday, and then the White House itself on Sunday afternoon. There, you can find the links easily, I'm sure, online by going to find them. They're very important, and it helped clarify a lot, which really showed that a lot of people were not impacted. And the language is very specific and clear that if a petition was filed before September 21st, whether it's approved or it's in process, but if it was filed before September 21st, this proclamation does not apply to that person. If the petition was filed, it doesn't say after the 21st, but it also says if someone is in possession of a validly issued H-1B visa, this proclamation does not apply. So there will be a number of scenarios to walk through, and I think it's important to walk through those so that you can see the exact examples. But the guidance is very important because it does at least specify who it really does not apply to, which could be actually a greater number of people than anticipated when the memo first came out. And again, reading the proclamation title is very important. It's a restriction on entry. So there are a lot of people that this will not apply to in the United States, perhaps even if a petition is filed after the 21st, but they're here in valid status, because this proclamation is all about limiting entry into the U.S. of H-1B workers.
Okay. That's super helpful. Jeff, anything to add before we dive into scenarios there?
No, no, let's move
Okay,
ahead.
great. Okay, so let's start with a case that's already been approved. Let's start with individuals who are in H-1B status today with an H-1B visa stamp on their passport, and they're currently just in H-1B working. Does anything here, do they have to pay this $100,000? Does anything impact them?
In my opinion, no. This does not impact them because the petition was filed or approved before September 21st. They have a valid visa, and CBP has made clear that if individuals who have a valid H-1B visa travel and come back to the US, they will be admitted. This proclamation does not apply.
Okay, great.
And I can address someone who does not have a visa, because there are plenty of people who have an H-1B petition approved because they
That was my
changed
next one. You
status.
got it.
They changed status previously and have not traveled internationally since then and need a visa because they need to travel. In my opinion, they do not, this proclamation also does not apply to them, because it is clear in the guidance that if the petition has been approved, it does not apply to that individual. So it is our understanding from reading the guidance, that a person with an approved petition can leave the US, apply for a visa, and come back, because that prong of having an approved petition before September 21st is there.
Malvena, I want to clarify whether or not it's a filed petition or an approved petition, because there are many people right now who have H-1Bs filed for them, and they were filed before September 21st, but they're not approved yet. And can you do two scenarios? One, if you have filed, but you don't have an approval and you're inside the US, and one, if you have filed and you don't have an approval yet and you're outside the US.
Okay, great. So filed, but you don't have an approval yet, and you are in the US.
Yep.
In my opinion, the proclamation does not apply, because it is very clear through all the guidance that this proclamation only applies to petitions filed on or after September 21st. So it is my reading that if the petition is filed and you're waiting for an approval, if it gets approved next month, December, January, and you want to leave and apply for a visa, you should be able to get that visa and come back without paying the fee.
Great.
So the second scenario you mentioned, it's filed and
they're outside the US.
and the person is not here. Again, if the petition was filed before September 21st and they are not here, they should be able to apply for and receive their visa and enter the US, because again, it's very clear everywhere. All of this applies only to petitions filed after September 21st.
Great. Okay, that's really helpful. We have a lot of our folks on the call here who are foreign nationals who have filed concurrent petitions. And so I want to make sure to address that scenario where you have a part-time visa that has been approved potentially with Open Avenues or another employer that is cap exempt, and you are filing a concurrent visa on top of a cap exempt H-1B, and that concurrent visa was either not filed yet or has been filed but not approved yet. And if the proclamation, like how we're thinking about these concurrent employment scenarios. And Jeff, I know we talked about this earlier, so either one of you want to talk about what this means. This is specifically for folks in our fellowship program, and anyone doing a concurrent visa scenario right now.
I'll take that, Danielle. If a cap exempt H-1B organization filed an H-1B petition for a foreign national prior to September 21st, then an H-1B entry based on that petition that was filed prior to the 21st is not subject to the $100,000 fee. Now, if a concurrent employer also filed their concurrent petition prior to September 21st, that is not subject to the $100,000 fee. But let's say the concurrent employer hasn't filed yet, and they want to file, and they want to file this week. Let's say the foreign national is inside the United States and they're in valid H-1B status with the first employer, the cap exempt H-1B employer. Yes, the concurrent employer can file. And there's no fee due right now because they're only filing either an extension of status or an amendment, and you can do that without invoking the fee. However, when that person, that foreign national, leaves the United States, they will need an H-1B visa in the passport to come back. They certainly can get an H-1B visa based on the cap exempt organization's petition that was filed prior to the 21st. But if the concurrent petition was filed after the 21st, a fee must be paid before that person enters the United States. And that's the only thing I can say. If the foreign national can go to the consulate and get an H-1B visa based solely on the petition that was filed prior to September 21st, enter the United States, they can then be employed by
Which is,
both.
and that's what we were advised. We're going to be advising that concurrent employers, if there is an approval on just the 5 hour per week cap exempt H-1B, and they have that approval, and or if this was filed ahead of September 21st, individuals can enter on that visa without having to pay a fee of $100,000, and the concurrent petition can be filed when they arrive here.
Yes, that's
And
right.
the reality is companies, if you filed only the cap exempt through Open Avenues or the Build Fellowship program, then that's going to be okay, and there's not going to be a need, most likely, from our read today, to pay for that $100,000 fee. Okay, so we'll Malvina, anything to add to that?
No, that covers it. And I think as we discuss each of the particular scenarios, it should become more clear because there are a lot of moving parts, whether you're changing status, amending whether you have a visa or not. So
Yep. Yep. Okay, so let's talk about individuals in the United States who are going to be entering the lottery moving forward and trying to get an H-1B. They're in OPT, it's expiring, and they are going to enter into the lottery next year. What are their options at this point? What does it look like is going to happen? Malvina,
Well, this is
yeah,
go ahead,
sure.
Jeff.
well, this is supposed to be a restriction on entry. So if there's no reason why a person immediately needs to enter the US, there should be no fee assessed. So if someone is in valid F1 status and they win the lottery in March of 2026 and their H-1B petition is filed with USCIS, there's no need to attach a $100,000 fee if the employer is requesting a change of status inside the United States. However, when that H-1B is approved and the person is now in H-1B status, if they choose to leave the United States and they're making an entry, they're entering based on a petition that was filed well after September of 2025, and there will be a $100,000 fee assessed at that time.
Malvina.
And
Yep.
one more thing, I do believe that if the employer wins the lottery for someone who is outside the United States, when they go to file the H-1B petition, I think they're going to be required to pay the $100,000 fee immediately with the filing of their H-1B petition because the government is already surmising that that person will have to enter the United States in H-1B status, and they want to collect the money right away upon the filing of that H-1B petition for someone who's outside the United States.
Okay, so to be clear from our read here, a change of status, if you are in the United States and you are entering into the lottery. It doesn't matter whether you're in H4, whether you're in an L-1B, or you're in a in F1 status. If you have an expiring visa and your choice and your company wants to enter you into the lottery, you are going to be able to potentially get that approval for the change of status, and you can be in the United States, and you don't have to attach $100,000 to a petition. But when you want to leave and go get your visa stamp, you will have to have evidence that you have paid this $100,000 if you're going to come back in. Is that correct? Because I think that's a really this specifically is going to impact most companies who are on this call, and a lot of folks who are looking to figure out what their next step is in the lottery next year.
That's exactly our understanding of it. Because again, it's all about limiting the entry of H-1B workers in the U.S., which is all the president can try to do under the limited authority that he has. But if you're in the United States, you're changing status, even if a petition is filed after September 21st, you should be able to change status here because you're already here. It's the clincher is if you need to travel. That's
Okay.
where they're going to get you.
Obviously, for anyone listening, this is a pretty, I mean, if things proceed, we'll talk about, court options and litigation and temporary restraining orders and what could be happening soon. But if this proceeds, there could be some really challenging scenarios for foreign nationals that are faced with a reality where they have this change of status approved. They can get into an H-1B status, but they have to decide if they travel, they're not going to be able to come back without that $100,000 payment made. And so that's really devastating reality for people if this isn't if we don't get additional clarification that tells us otherwise. Can we talk about whether or not cap exempt H-1Bs are mentioned throughout any of the memos or proclamations at this point, and how you two are reading the impact for cap exempt H-1B petitions filed?
Cap exempt has not been mentioned anywhere in any of the language of the proclamation or any of the guidance. The fact that they could not get straight the difference between petitions and visas and why they had to issue clarification. It's unclear whether they even understand whether cap exempt H-1Bs exist and whether there should be given special, treatment of them. So cap exempt H-1Bs have not been mentioned at all. The only potential kind of waiver or exception that they talk about is if it is found that the foreign nationals' work is in the national interest of the United States and that they will not be a threat to the security of the United States, which is also very vague as well. It at least opens the door possibly for some limited exceptions of people who might be able to fall under that scenario, but there's been no further guidance yet about that. So we would definitely look forward to any specifics that they come out with. Hopefully, if we press the government with some more questions about giving us specifics, they'll give us that, and that might be an option.
Okay.
There's lots of classes of people who should receive a blanket exception because they are critical to the United States and they don't pose any particular threat to our country. Doctors, nurses, healthcare workers. One person just posted a question, what about periodontists? I don't know. There's an endless list of professions that could receive a blanket national interest exception. Even educators, such as the fellows in the Build Fellowship, they are people who are adding important things to our national interest. We don't know yet how broad they will consider the national interest exception, and we don't know if they're going to issue any particular classes of professions that are included.
I don't think we can underscore this concept enough. I mean, we know nothing. Like, there's a scenario where the national interest exception includes AI and, like, who knows, like STEM generally, it could be blankets. Like there could be chaos that's created by this administration by putting out a statement that everyone owes this fee, and then we see exemptions that are really applicable to massive amounts of individuals. We don't know the answer to that. We don't know whether cap exempt organizations will qualify as nationally in the national interest right now. And we don't know if it's going to be some like, healthcare occupation. So again, an unknown that we're going to keep everyone updated on. But we can't underscore how large that unknown is. It could be as small as having doctors be the only carve out, which the White House emailed to Bloomberg today is a potential carve out of this. And it could be as large as saying there's a cap exempt H-1B carve out or a STEM carve out, right? We just don't know what qualifies as in the national interest. So we need to stay tuned on that in general. But to summarize, cap exempt entities today are not exempt. However, the cap exempt H-1Bs like Open Avenues and the Build Fellowship can continue to file change of status petitions. Again, the challenge comes when people want to re-enter and they haven't already received a visa stamp. We got a couple questions of folks who are going, and this is commonly a question. If you're in cap exempt H-1B status, you win the lottery and you have a cap subject petition filed for you. Is this a new petition with a new visa stamp, or is your cap exempt H-1B visa stamp for the H-1B still valid? And you're really doing an extension of your H-1B, and it's not a new petition, and therefore you don't have to pay the $100,000. Does anyone have a take on that?
That's a really good question, Danielle, because as you know, under the current H-1B regulations, anyone with a valid H-1B visa in their passport can use it to enter the United States. It can have any other organization's or employer's name on it. It has always been allowed for that person to use the H-1B visa together with another approval notice from a different employer or organization to enter the United States. So there's no specification in the guidance or the proclamation if that visa must match the approval notice that they are entering the US with. I would think not, because it's always been in the regulations. You can use that visa. And all the guidance says is that if you are in possession of a validly issued H-1B non-immigrant visa, then this proclamation doesn't apply to you. So I would think that if you had received or been issued an H-1B visa through your cap exempt H-1B petition, you've now won the lottery, and your new cap subject status takes effect on October 1st, you should be able to travel abroad and return to the US without having to apply for a new visa, but using the visa that you already have in your passport through the cap exempt organization to return to the US.
Thank you. To summarize, anybody who has the H-1B stamp through the Open Avenues or Build Fellowship program can continue to travel with that visa stamp, even if you win the lottery and change to a new employer. We did have a question on renewals and extensions. Jeff, or Malvena, can you talk about for H-1B extensions? I think it's the same concept where if you already have a visa stamp, it continues to be valid. If you change employers, can you talk through those two scenarios?
The actual filing of an extension application will not trigger the $100,000 fee at all, period. Extensions are not triggering the fee because that's for a person who's inside the US, invalid H-1B status. That's when one would file an extension. Yet, if the extension is filed after September 21st, then if the person departs the US, they will need to pay the fee when they come back.
Okay. Got it.
And I was going to say, for the change of employer petitions, it's very similar to the extensions and also amendments. You're in H-1B status right now, you're changing employers, so the new company must file its own H-1B petition to change employers, to allow that H-1B worker to begin working for the new company Again, it's our reading of the guidance that even if that petition is filed after September 21st, it's only to change employers to extend the person's status in the United States. It is not marked for consular notifications for the person to go abroad and get a visa. They are here, and it should not impact them because they are changing employers. They are not leaving and entering the U.S. And again, this proclamation is all about restricting entry. So it's our reading of this that change of employer petitions filed here, so the person can begin working for the new company, should not have to pay the fee.
Do we have any idea about folks who are coming in now on a B1, B2 and decide to file an H-1B while they're here? Are you thinking that you'll both recommend folks do that, or do we have to wait and see?
I think that's probably not a good idea to do right now. I know that not many, but a number of people have done that in the past. They happen to be here traveling, they're networking, they find a job, they find an employer who can file a petition for them, and they often will do that. They will change status from B1 or B2 to H-1B. But the proclamation does bring up that point that they are aiming to somehow crack down or look into individuals who they deem are abusing the B1 or B2 status to then change status to H-1B to possibly get around the proclamation. So I think while USCIS has never given that much scrutiny to individuals who have been here in B1 or B2 status, and then an H-1B petition is filed for them, I think that scrutiny could change based on this proclamation. USCIS will be alerted to it and may request more information through a request for additional information about why they're here, proof that they were visiting, the whole legitimacy of their visitor activities while they were here. So I think based on this proclamation, without any additional guidance yet, I would refrain from filing a change of status petition if you are here in B1 or B2 visitor status.
Mm-hmm. And what about, can we just go back to some of the basics? We're getting a lot of questions on, is this per employer or per fellow? And also there's a 1 year time limit on that. So if you could comment on those two logistics, that would be helpful for people.
The $100,000 fee is per person, not per employer. Per person. And it evidently might need to be paid again each year. But you get 1 year of the ability to come and go for paying the $100,000 fee if you're subject to payment on the fee. I think one excellent question I saw posted that we haven't fully vetted out yet is who must pay the fee? Must it be the employer or could it be the employee? As probably most people on this call know, both the Department of Labor and the Department of Homeland Security have a rule that all H-1B fees must be paid by the employer. And that specifically includes government filing fees and the legal fees. I think the government right now, the Trump administration, is bending over backwards to make sure that this $100,000 fee not be considered a filing fee. In fact, they're coming out and making that statement, and they're doing this for several reasons. If it is considered a filing fee, then filing fees cannot exceed the reasonable reimbursement to the government for the time it takes the government to process an application. Well, the $100,000 way exceeds the reasonable cost of processing an H-1B petition, even if they want to add an extra background security check. So they don't want it to be a fee for that reason. And moreover, they did not publish this new fee in the Federal Register and give the public time to comment on whether this is a good idea or a bad idea,
Right.
which is required by the law on all new fees. So the government doesn't want this to be considered a fee. It's more of a penalty on an entry. Now, therefore, I don't think it matters who pays the $100,000. I don't think you're limited to it being only the employer.
Jeff, this gets us into some of the challenges that are going to arise in court uh, regarding the proclamation and the legitimacy of this rule. Can you talk about one, what is the timing? I know you're talking to folks about litigation. You posted that you're looking for, you're supporting. I know Greg Siskin's leading charge here and looking for folks to engage. Can you talk about one, what is the timing for any of this to actually be filed? And two, would really like to hear what you think the legal arguments against this are, because if strong, we it really does change the reaction from industry potentially.
I think the timing of the litigation is imminent. Um, Several of the leading immigration litigators in the country are coming together to work on this, and they already have found numerous plaintiffs to volunteer to bring the action against the federal government. The plaintiffs so far include universities who are immediately affected by this rule because they are able to file cap-exempt H-1B petitions immediately, trade organizations who represent cap-exempt organizations who are immediately affected, some cap-exempt organizations themselves, and they have individuals who are immediately affected by this because under all of these rules, they would be subject to paying the $100,000 fee. And they plan to file, I think, within a week, and they plan to ask for a temporary restraining order to get a judge to immediately restrain the implementation of this proclamation. I'm optimistic when I look at the legal reasoning that I'm quite sure these litigators are using. I'm fairly optimistic. I think the biggest reason why a court should stop this is the proclamation itself says that the president is issuing this proclamation under Immigration and Nationality Act, Section 212F, that gives the president authority to set restrictions on entries to the United States that he may deem proper. But courts over the years have commented on restrictions that many presidents have tried to impose on entry into the United States. And there are dozens of courts who ruled that the president may not invoke this authority to address a purely domestic consideration, such as high unemployment in the tech sector. It can only be used for international reasons why our country needs to stop the entry of certain people. Other courts have said that the president cannot use INA Section 212F to subvert other sections of the Immigration and Nationality Act. In this case, the H-1B regulations, the law, and the regulations which support the law. And that's exactly what the president is doing. And finally, there is a law that says any action taken by the federal government has to have a rational relationship to the problem being solved. And I don't think a $100,000 fee has a rational relationship to stopping the problem of some employers cheating in the H-1B regulations. So I think there's a lot of good reasons why this lawsuit could succeed in getting a temporary restraining order issued.
And can you just explain what a temporary restraining order does and how it immediately impacts the rule itself?
Yeah, a temporary restraining order is issued by a judge who says there's an urgent situation happening right now at this moment, and I need I am going to issue a restraining order to keep the status quo, to not let any changes be implemented at the moment till we can all take a breath and have a full hearing on the issue. At that hearing, the plaintiffs in this kind of a lawsuit will be looking for the next step, which is called a preliminary injunction, where before there's even a trial, the plaintiffs are asking a judge to not just issue the temporary restraining order that's good for a week, but to issue an injunction stopping the implementation of this rule until a full trial on the merits can be heard. And what happens when you ask for a preliminary injunction? The judge, if the plaintiffs are asking for the injunction, the judge will take all of the facts of the case that the other side, that the government agrees to, and even if the judge agrees to everything the government is saying, if he still finds they shouldn't be allowed to issue this $100,000 fee, the judge will issue the preliminary injunction. That usually puts an end to the whole thing, because the cost of having a trial on the merits is so great to both sides that there usually is never a trial at all. The case just stops if a judge issues a preliminary injunction.
Mm-hmm. Okay. And what should people be thinking in terms of taking action right now? I mean, I think it's worth taking a pause and recognizing the reason the plaintiffs are cap exempt organizations is because from today through next April, no one's really filing cap subject H-1Bs.
It's not
And
possible.
it's
It's
not
not that they're not
possible.
really filing, it's impossible.
And 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 the rule was if you filed before this weekend, you for cap subject or cap exempt H-1B, if you filed before September 21st, you are exempt from having to pay at all. So I think there's a lot of people asking nuances. What if I was, filed, but I'm not in the US, or I filed for an extension, or as long as you filed prior to September 21st, this doesn't apply to you. Now, from today to next April, there are only really cap exempt H-1B petitions being filed. And the cap exempt organizations are the ones who are going to be hurt immediately by this change. That's why already we saw the White House come out and say, well, doctors might have a national interest exemption because hospitals are saying, I have to file for hundreds of doctors in the next month to be able to help the state of Kentucky, whatever, right? Like there are cap exempt organizations who have challenges right now. So the litigation is going to be driven mostly by these cap exempt organizations who have the imminent challenge. And so the plaintiffs in this case has shifted a bit to be the cap exempt organizations that feel that imminent threat. Now, many of you are going to be looking at what happens in April on. And so by then we will certainly have clarity as to the results of these court cases and what happens. So there's a lot of people probably here that this is not imminently impacting, but many of you, I'm sure, are thinking ahead to the lottery and figuring out what your situation is going to be. Jeff and Malvena, did you see any questions that came up to discuss specifically? There's a lot of questions that are going on in the chat right now. We've covered a ton.
Right. I will say there was one person who asked about H-4 dependents. And because I'm sure there may be scenarios where the H-1B principal is here, they have family that were abroad or need to get visas and come here. And how is that impacted? There is nothing in the proclamation or the guidance that refers to H-1B workers and their dependents. And certainly someone who is a spouse or a child under 21 can get an H-4 visa if the H-1B principal employer is in the United States and is working in valid H-1B status in the United States. So it's our understanding that an H-4 dependent can get their H-4 visa if they need to and travel to the United States, or if they already have an H-4 visa and need to leave the US and return, that they can, because there's, again, nothing in any of the documentation or the guidance that includes dependents.
Okay.
So hopefully that will help some people.
Danielle, first of all, I wonder if there's a way we can take our time after this session and answer the questions or and get them
Yeah,
to people.
I
So
think that's a good idea.
so we will be doing that. If we can't directly get it to everyone who registered, we'll certainly be posting it on the Build Fellowship website and the website of Goldman and Partners Immigration. But I am seeing that although the whole crux of this webinar is based on who was subject to the $100,000 fee, and we've been discussing it for 50 minutes, there are people who just a few minutes ago were posting the same questions. So I
Yeah.
think we should take a second, and maybe it's the last thing we're going to say, but let's just review one more time who is and who is not subject. Number one, anyone who already filed an H-1B petition prior to September 21st, which was yesterday. It was already filed with the government, which means received, which means the government had it in their hands and received it. They are not subject to any $100,000 penalty at all because of this H-1B petition that was already received. If you mailed it on Friday, but it wasn't received until today, it's too late. That does not count. It's the day the government receives it. It's not the day they send out the receipt notice. It's not the day FedEx picked it up. It's the day the government received it. So number one, if the government received it prior to Sunday, yesterday, no $100,000 penalty. Moving ahead, all H-1B petitions that are filed starting today, moving forward. There are some that are definitely not subject to the $100,000 fee, and those are H-1B petitions looking for an extension of status for someone who's in the United States in H-1B status. You can file, no fee due upon the filing. A change of employer. You're in H-1B status with one employer, and now a new employer files a petition for you next week. You're in the United States, not subject to the $100,000 fee. An amended petition because you get a new job title, a new location. There's a reason why an employer had to file an amended petition. You're inside the United States, no fee is due. But for all of those where there's no fee due, if the petition is filed after yesterday, there will be a fee due if you depart the United States and want to make an entry, because now your entry is based on a petition that was filed after September 21st.
Oh, Danielle,
All
you're
right,
on
I'm
mute.
on
Yeah.
mute. I want to emphasize this. A few employers are in the call right now trying to understand the concept of this. I see that we have employers asking if we are going to have to file, if they file a concurrent visa or a visa for their employee who's in the cap exempt program, or whether they file a change of status directly for a new employee in H-1B and they leave the US, are they like they're going to have to pay this fee or no? Can you make those are two separate scenarios?
Well, if the person has a valid H-1B visa in their passport, which can sometimes happen, you get an H-1B visa through a prior employer or through the cap exempt organization, and then the concurrent employer files their petition for you. You need to travel. It is very, very clear from the guidance that if you have a valid H-1B visa in your passport, you can travel to the US and come back. So in those situations where an employer is filing an extension or a change of employer or some other amendment, and the person has to leave, if they have a valid H-1B visa in their passport, they will be let back into the US without having to pay the fee. It's when you have to apply
Malvena,
for.
valid H-1B visa in the passport prior to yesterday. It can't be a new visa
Yeah.
that they're getting this week.
Oh, correct. Right.
Okay.
Okay. Okay. Got it. So if they have this visa already in their passport, confirming for everyone, no employer is going to have to pay a $100,000 fee. But in a new petition being filed, even if the individual is inside the US, they can either stay there and they can stay here in the US and not leave. But if they leave and you want to come back in, they're going to have to go to the consulate and get a visa stamp, which we've historically it's been no problem. But now they're going to have to get that visa stamp and demonstrate they've paid $100,000 to get back in. So employers are going to have to talk to employees and decide whether or not you're interested in doing these change of status petitions for folks in F1 or who are in the US in a different status and want to stay here. It feels very unfair. I see there's comments on that. We agree, of course. We have a lot here. We're just parsing through a bit. Jeff, do you see anything you want to address?
It's almost overwhelming. You all have great questions, and they're all a variation on the same theme. And it's impossible in the next 4 minutes to answer all of them.
Yeah.
Thank you for the person who just said we need another webinar. It is true, and we
Okay.
will be putting on
So
more
I have
webinars as we move ahead.
Yeah, our team is already on it. We're planning a webinar for tomorrow morning, a follow-up for any employers who have employees in the Build Fellowship program or fellows in the program. We're going to plan a follow-up for tomorrow as well, because we want to make sure you get one-on-one or more personalized Q&A. We have a few minutes left. I'd like to actually talk directly to our fellows and to the foreign nationals who are interested in cap exempt H-1Bs. Our guidance right now for our fellows is that, again, if you're in the United States with a visa stamp currently in your passport, you can travel freely, no problem. We have some fellows outside the United States in cap exempt H-1B. You already have a visa stamp in your passport, or you're getting a visa stamp in your passport. As long as you have the approval already, or you have filed already prior to September 21st, you can re-enter and come in without paying the fee. There are some individuals on this call who have visas that are being put together, petitions being put together with the GPI team. So for anyone who has an H-1B cap exempt that's in development, Jeff and Malvena, can you talk about what we do here for the in development petitions? This is where the employer is going to have to make a choice.
Right. I think it's most important to really discern what is their status? What is their status in the United States? And what if they are in the United States, what are their plans? Do they have any international travel plans that they might need to travel without question, that there is simply no alternative? They simply must travel for a very extremely important reason. Perhaps it's best to wait before filing that petition. If there really are no plans that the person has, then they can definitely stay in the US for the next 6 to 12 months and without any anticipation of traveling, then I think they should move forward, especially if their status is expiring. So it's very important to find out what their status is, what their international travel needs are, and their plans, and then decide from there whether we kind of put a pause or we keep on going.
Okay. We're going to be answering every fellow and company's questions one by one via email. So please reach out to us directly. I We'll definitely make sure that we take note of the questions that are in this chat now, and we'll circulate more here, more answers here. We also will plan an additional webinar for tomorrow for everyone in general to come back. And if there are any updates, we'll discuss it further. If you need to listen to all of this again, we will discuss it and make sure we have a thorough dialogue because there's a lot to cover. It's actually quite comical that I thought we could do this in a half an hour at some point because there's just so much to cover here and there's a lot of good questions. We will be sending the recording out to everyone so you can digest what we discussed. And we look forward to staying in touch. Please, we will send out everything via email and you can join us again tomorrow. Thank you so much. Take care, everyone.